Madam Speaker, yesterday the Rules Committee met and reported a rule, House Resolution 1372, providing for consideration of H.R. 8873, the Presidential Election Reform Act, under a closed rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on House Administration, as well as one motion to recommit. This bipartisan legislation, brought forward by Ms. Lofgren and by Ms. Cheney of Wyoming, is the product of more than 2 years of work by the Committee on House Administration and more than 1.5 years of deliberations and investigation by the January 6th Select Committee. The Electoral College, of course, has been with us from the beginning of the Republic, and in a sense, this legislation America has been working on since 1887, for the last 135 years, because that was the last time that Congress legislated to try to lend statutory coherence and legislative direction to the provisions of the Constitution governing the Electoral College. The Electoral College, as you know, Madam Speaker, is a Byzantine, complex, and multifaceted institution, but it is clear in the wake of the debacle of January 6, 2021, that we must modernize it, update it, and make it work as well as possible for as long as we have it. That's why both supporters of the Electoral College system and those who would replace it with the national popular vote for president, and that is a camp I am in, a camp that represents around 2/3 of the American people, are strongly supporting this legislation and should be supporting this legislation in order to clarify the mechanisms of our presidential election process. First of all, this legislation reaffirms that the Vice President's role at the count of the Electoral College electors on January the 6th is a ministerial role and does not include any substantive authority to count or reject or dismiss or nullify or vaporize Electoral College votes sent in by the states, nor does the Vice President have any independent substantive power to halt or delay the joint session or to return Electoral College votes to the states. We believe there was never any ambiguity about that. The former President, Trump, was told there was no ambiguity about it by his own Vice President, by his White House counsel, by the Attorney General of the United States, and yet insisted that there was some kind of ambiguity and wiggle room for the Vice President to step outside of his assigned constitutional role and simply declare the Electoral College votes of certain states, including Arizona, Georgia, and Pennsylvania, null and void, and returning them to the legislatures of those states for some undefined further action. All of that is clearly outside the history of the Electoral College and what's contemplated constitutionally. We clarify that in this legislation. Moreover, the current provisions in the Electoral Count Act governing objections brought forward to the receipt of Electoral College votes from particular states would be changed in this legislation. Under the current rules, all it takes is a member of the House and a member of the Senate to bring an objection to the receipt of Electoral College votes from a state. That would be changed to a requirement under this act of 1/3 of the House and 1/3 of the Senate together raising an objection, obviously meaning that this could not be done for purely fanciful purposes. There would have to be a substantial body of members in both chambers who agreed that there is a serious objection being made. By the way, the Senate proposal it differs slightly in that they are suggesting a 1/5 requirement on both sides as opposed to the 1/3 requirement that is being advanced in this legislation. Furthermore, the rules in this statute define explicitly the constitutional grounds upon which an objection to Electoral College votes can be made. These objections are limited to a very narrow set of discrete issues that are grounded in the constitutional text of the 12th Amendment or other parts of the Constitution, such as whether an elector has voted for 2 candidates from the elector's own state, which is clearly in violation of the 12th Amendment. The rules also clarify the denominator, or the method of calculating the whole number of electors that have been cast for the purpose of winning a presidential election. Our counting rules would also clarify the applicable parliamentary procedure at the count, ensuring that strategic bad faith actors are unable to exploit procedural loopholes in an effort to delay or subvert the count. Confusion has plagued electoral counts in Congress at different points in our history, almost since the beginning of the Republic. We are confident that under this bill, future counts will be far more orderly and ministerial in nature, even during controversial elections, and will act simply to certify the choice of the American people as expressed through the state elections, which is the full extent of Congress's counting role under the Constitution. We want to make sure that Congress does not pretend to arrogate to itself the power to decide who is going to be the president. The role of Congress is simply to count the Electoral College votes that have come in. And maybe if I get a moment later, I can get into a little more specificity about the grounds for objection. There's also clarification of when a state's presidential election can be extended in case of a truly catastrophic event. Today's federal law allows the state legislature to appoint electors by itself if a state has had a failure to elect at its November election. That very vague provision is dangerously unclear, and it was targeted by former President Trump's supporters in 2020. Our legislation provides instead that voting in a state's presidential election can only be extended if a state experiences a genuinely catastrophic event, which we define specifically with respect to natural disasters and terrorist attacks and like calamities. The event must also be widespread enough to potentially affect the outcome of the state's election, and all of this is mediated judicially by appearance before a federal court. Any extension may only cover the area that was directly affected by the event, and any extension cannot last longer than 5 days after Election Day. And we know that a provision like this is unfortunately necessary. The September 11th terror attacks on America occurred on primary election day in New York City, and Hurricane Sandy in 2012 very nearly derailed New York and New Jersey's presidential elections that year. But we're confident that our bill ensures that federal law will account for unforeseen emergencies in future presidential elections. There are other provisions that I hope to get into in a little more detail, but I would close, Madam Speaker, just by saying that this is an absolutely necessary and urgent update of the Electoral Count Act, which hasn't been touched since 1887, and we saw in January of 2021 how some of the imperfections in the current process can be exploited by actors who are determined to derail the Electoral College counting process or indeed overthrow the whole election. So we want to do whatever we can within the confines of the Electoral College system in this legislation to improve the situation and to prepare for the next presidential election. I'll reserve.